Good day, everyone. My name is John Cornwell, and I'm the Director of Practice Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's webinar, and I'd like to begin by thanking everyone for joining us today. As you may know, a recent decision by the Michigan Supreme Court has fundamentally changed the ability to defend premises liability cases in the state. And given the importance of today's topic, we're fortunate to have with us Rick Simchak and Aliana Saikhan from our Torts and Litigation Practice Group. More about them in just a few moments. Before we get started, I want to provide you with some background about our law firm. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan, is one of the Midwest's oldest and most accomplished law firms with approximately 130 attorneys. We have 7 offices located throughout Michigan. We also have offices in Chicago, Illinois, Columbus, Ohio, and Indianapolis, Indiana. Our Torts and Litigation Practice Group includes attorneys who focus on all aspects of liability, including food service, hospitality, pet and premises liability, as well as dram shop and the defense of related litigation. Retailers, hospitality establishments, municipalities, and commercial property owners are among the types of businesses that directly retain our attorneys to resolve these types of disputes. Our attorneys also serve as litigation defense panel counsel for some of the world's leading insurance providers. As I previously mentioned, we're joined today for this discussion by Rick Simchak and Aliana Saikhan from our Bloomfield Hills, Michigan office. Rick is a partner of the firm and a member of the Michigan Defense Trial Council and DRI, which is formerly the Defense Research Institute, for those that may know that organization from years past. With 45 years of experience, his litigation practice is diverse, and in addition to premises liability cases, it includes insurance coverage disputes, no-fault and third-party motor vehicle liability claims, title insurance matters, and banking law issues. Aliana is a member of our Torts and Litigation and Governmental Law Practice Groups. Her practice includes the defense of litigation for private and public sector clients. She has expertise in such areas as personal injury, slip and falls, product liability cases, civil rights matters, and disputes involving education law issues. Now, before I get started, I need to cover just a couple of housekeeping notes about today's program. At the end of the webinar, we will take as many questions as time permits. If you'd like to ask a question, simply type it into the GoToWebinar questions window located on your dashboard. You can do that anytime during the program. And again, we'll take those questions at the end. Please note that our session today is being recorded, and that recording will be available on our event page at the Plunkett Cooney website, which is located at plunkettcooney.com. Again, thanks for attending today's webinar, and with that, I'll turn the program over to Rick and Aliana. Rick, I believe you are up first, so please take it away.
Very good. We are here today to discuss something that happens very rarely in the law, a massive change, making a complete reversal, and instead of going forward with something new, we are going into something old. Interesting to look at this slide and see the DeLorean, because the Michigan Supreme Court is forcing us into a Model T, not a DeLorean. And the style here is strictly old-fashioned. Let's talk a bit about what's gone on. We had a defense in premises liability cases called open and obvious. It was really crystallized in the Lugo versus Ameritech Corp case, but has now been completely overruled as wrongly decided in the Kendall El Sayed versus F&E Oil Inc. and Pinsky versus Kroger cases. So what we've had is a change in the composition of the Michigan Supreme Court, equaling a significant and dramatic change in the law. To give us some context, let's look at what we really had for the law previous to this most recent decision and dramatic decision. We've said it's drastic. We said it's a step backwards because we are going back away from open and obvious. We are discounting that as a defense, and really we are going back to the old-fashioned way of comparative negligence. Now, I'm one of the few people who probably can remember back before open and obvious was truly an applicable doctrine in premises liability. And when we really were limited simply to comparative negligence in terms of what the defect was and how the individual was injured and the interplay between those two factors, the defect and the individual. But in this particular instance, we are going backwards, and the DeLorean of legal doctrine is being slammed into reverse. Moving on, as Marty McFly says, it's an oldie. Well, open and obvious was an oldie, but it was very definitely a goodie. Under the old rule, and this goes back further than Lugo, this goes back to 1992 in the Riddle versus McLeod case, duty was separated from comparative negligence. Open and obvious was a duty question. If the defect in the premises was open and obvious, no duty was owed to the invitee. That was when open and obvious was adopted in Riddle and then developed and crystallized in Lugo. We were departing from existing law, but we were separating out the concept of duty from the concept of comparative negligence. And Riddle, citing Williams, and then on to Lugo, all addressed this idea of duty being an initial inquiry. Before we ever get to the comparative negligence, the question was, did we have a duty? The question was, did the premises owner have liability if there was a duty? But we were applying at that point an objective standard, a focus on the defect. Would a person of reasonable intelligence on casual inspection have seen the alleged defect? Nothing else mattered except whether the defect could have been observed. A little later on in Lugo, we have something different, but with the special aspects. But again, it was the question of whether it was open and obvious. When open and obvious was adopted, it was applied in virtually every premises liability case, not always successfully, but in many occasions. The Robinson versus Tyler case on the screen now was one example of where the objectivity of the test focused on the risk, whether the defect was there and could have been observed by the average person. In this particular case, the plaintiff was visually impaired, but that didn't matter to the inquiry. The inquiry was, would the reasonable person on casual inspection have seen this? Because the trial court and the Court of Appeals both determined that the defect would have been observable on casual inspection, the case could be dismissed. I cannot point out the number of times people have pointed to this unpublished decision and said this was an example of taking the defense of open and obvious to a ridiculous extreme. There were a few cases like this, but there were several cases that did apply open and obvious in this kind of a circumstance where it didn't matter what the condition of the plaintiff was. The only thing that mattered was, can a reasonable person under the objective standard have observed the defect? Moving on, we kind of get into the idea of what happens now that we have this particular case. And so this is where destiny comes in. Destiny really applies. Aliana?
So I'm going to jump in here. What we know about the Kandal, El Sayed, and Pinsky cases is that but prior to those decisions, there had long been some rumors and rumblings from the personal injury bar that something was coming. We knew that the tide would be turning at some point and that the days of open and obvious were numbered, so to speak. And this kind of shop talk was fueled by our knowledge of the differences in ideologies and the way that the Michigan Supreme Court was changing election by election. But what was surprising when this decision finally came out was exactly how broad the language of it was. So instead of even leaving us with a little bit of wiggle room as to open and obvious, the court ended up doing away with what was our complete defense. So open and obvious as a whole was very much dismembered. We can move on to the next slide, John. So to be sure, Lugo, which is the case we had referenced previously, was very explicitly overruled twofold. A little bit more about Lugo. It was the 2001 decision that provided a very expansive interpretation of what open and obvious was. And you may be familiar with the language from Lugo regarding special aspects that was very often used in some of our defense briefs. It was that case that said an unguarded 30-foot deep pit in the middle of a parking lot was an example of an open and obvious condition that was unreasonably dangerous. So it wouldn't be uncommon for us to be able to say and to use Lugo as a reference in a dispositive motion, saying something along the lines of, well, the condition at issue is hardly like that 30-foot deep pit in Lugo. But instead, we now see that the Michigan Supreme Court has done a 180 on that kind of thinking. Instead, now we see them holding that open and obvious in the nature of the condition is relevant to breach and the party's comparative fault. And also that special aspects doctrine has been overruled. So a land possessor should anticipate the harm that results from an open and obvious condition despite its obviousness. And so we see that complete defense completely dismantled in this strong language. So much like we see Biff trying to give the boot to Marty McFly here, open and obvious very much got the boot with this decision. Looking at the sudden impact and the immediate offshoots from what happened this July is that we now see that this decision is applying to all new cases that are coming before the circuit courts and even the Court of Appeals. So the day the ruling came out, our strategies completely changed. If you had a motion for summary disposition that was not yet filed, you had to cut that open and obvious section right out of your brief. It changed the way that we were taking our depositions the next day and the way that we were drafting our discovery requests. So we were no longer searching for some kind of admission from the plaintiff that they had observed the condition and reasonably could have avoided it. Instead, we have to rely on some of our other defenses and build up things like notice. And this is going to be applying to all cases moving forward and all of the cases that are in the middle of discovery with dispositive motions pending. A reasonable question may be, what about those pending cases where we had already filed our motions for summary disposition or the ones that were up on appeal? Because of this decision without any further guidance from the Michigan Supreme Court, we have to assume that it is going to be applying to all pending cases, including those on appeal, unless the Supreme Court indicates otherwise. And at this point, it is very unlikely that the Supreme Court will address retroactivity. So we have to consider that this is going to be the norm moving forward. So again, this is going to be applying to all cases that are pending on appeal, all cases that are still pending in circuit court. And we're going to start seeing some of the matters that were before the Michigan Court of Appeals coming back, so getting remanded to the trial courts for trial. All right, so moving forward, where are we headed now? I'm going to toss this back.
Well, as we look at the slide, we don't need roads. Well, no, because we have no roads. We are going to be blazing trails now and throwing out our open and obvious defenses and going back to old-fashioned comparative negligence. And what do we do now? This is what we anticipate being the result of open and obvious being set aside by the Michigan Supreme Court. It almost certainly will mean more claims and more cases. The plaintiff public will be encouraged to pursue cases that they might not have otherwise. And so we anticipate that there will be a reasonable increase, perhaps even an avalanche of more cases addressing premises liability. In circumstances where you have longer standing conditions, such as curbs, stairs, fixtures, displays, we anticipate seeing more suits involving those kinds of conditions and claims that they're defective. Because of that, we are going to have to look for different proofs in addition to the elements that we used to explore on open and obvious in order for us to mount a defense. As Aliana said, we will focus on notice defenses as much as we can, especially with regard to the kind of temporary conditions that suddenly occur, like spills, leaks, in some instances, even snow and ice, as opposed to longer standing conditions such as the curbs, stairs, and fixtures. We are going to see a difference in our approach in this regard. And the difficulty that we have is we're going to have to upgrade our investigation of occurrences when they happen. It was already the norm that store video would be preserved and occasions photos taken and a statement taken from the plaintiff. But more is now required for us to mount a real defense. If there's more than one angle capturing the occurrence, then more than one angle, more than one camera video is going to have to be secured and saved. Photos taken contemporaneous of the condition, contemporaneous with the fall, or very shortly thereafter, will be necessary. Not just statements from the plaintiff, but from our own from premises owners, employees, and witnesses, other invitees, other patrons are now going to be required because we're going to have to develop a better means of defending now that the complete defense of open and obvious is gone. We need to do better at investigation. That will be the, I think, most important change here, because that will probably require a learning curve and some education on the part of premises owners, employees, who will now have to do a little bit more detective work and a little bit more evidence preservation in order to make cases defensible. John, do we have any questions?
Yeah, we knew this was going to be a quick update. That's why we only allotted 30 minutes for this call today, for this webinar. So, quickly upon us is the Q&A portion here. You've got the update today on what's happening in Michigan. If you can type in any questions into the questions widget, there is one that I could share, and the question is there any chance of rehearing by the Michigan Supreme Court on this?
Based upon what we know right now, given the language in the decision, in the decisions, both cases, we do not anticipate rehearing. We do not anticipate any leavening of the decision as it is. Open and obvious is gone, and we're back to comparative negligence, and that's going to be the law in the state of Michigan for the foreseeable future. So that's why the need for all of us who are involved in this kind of work to have to change our approach, have to make our investigation more sophisticated, and work harder at developing the facts as early as we can to be able to counteract the absence of what was a complete defense that covered everything.
Okay, thank you for that. There is another question. Excuse me, I just misread that. Can comparative negligence be a complete defense now that it is essentially replaces open and obvious?
I can take that one. So the big issue with the loss of open and obvious is that having a lien on comparative negligence is that it's never been a complete defense that you can really rest your head on. Comparative negligence is all about assigning a percentage of fault to the parties, whether or not the defendant was 30% at fault or 40% at fault or 60% at fault. It's not about ridding the defendant of all liability in the same way that open and obvious did. It's really about trying to establish exactly how much the defendant had messed up in that situation and assigning a percentage. So in that way, it doesn't function the same way that open and obvious did and can't serve as a complete defense.
To follow up just a little bit on what Aliana said, the reason that open and obvious was such an important part of our defense in premises liability was because it really didn't matter what the premises owner did wrong, if anything. It didn't matter what other factors there were. So long as the condition was open and obvious on reasonable inspection, that was a defense. And it didn't matter what else was done wrong, what else might have impacted that occurrence. Now that that's gone, we're back to evaluating the conduct of both the premises liability, the premises owner, and the plaintiff, and establishing and allocating fault, which almost necessarily means there is no such thing as a complete defense under comparative negligence.
Great, thank you. Another question's come in. Can you still use the term open and obvious to argue to a jury?
The doctrine's been rejected wholeheartedly by the Supreme Court in their decisions. As a legal concept, it is pretty much dead on arrival now. So I think that if you were going to approach this on the basis that the plaintiff still should have seen it and avoid it, you wouldn't necessarily use the terms open and obvious, but you might apply the same kind of factual elements, the same kind of evidentiary elements that you did in order to develop as much as you could the comparative negligence aspect. But using the term probably is going to attract more attention to the term than to the evidence you're trying to introduce.
Understood, thank you. Two more questions so far. And again, if anybody'd like to ask a question, just pop it into the questions area of your dashboard, and I'll do my best to get them in here. How do premises owners address the need for early investigation of an occurrence?
So that is really about going back to the drawing board when it comes to things like training and employee education. When we're going to be looking at our other potential defenses like notice, the idea with notice is that did the premises possessor have the knowledge and the opportunity to cure the alleged defect? So in order to build up our defense there, to say that we didn't have notice, it's all the more helpful, and even more so helpful now, to have things like comprehensive incident reports, to have contemporaneous witness statements, like Rick said, making sure that we have all of the store video and that your retention policy is robust, and we don't have to deal with things like spoliation accusations down the road because we're unable to produce that video. We really need to start, as Rick had already emphasized, building up our investigation, making sure that all of our bases are covered and we have this comprehensive information, statements from employees, statements from witnesses, video and photographs of the spill, all the more to prove that, we could not have known that this condition existed, that we have some kind of way to indicate how long the condition had been there, what the duration is, and that we couldn't reasonably have known about it. So those things become all the more important now that we're in this new landscape where we don't have the open and obvious defense, and we have to now establish notice.
And building on that, we're going to have to figure our ways out of this situation. But is this the kind of circumstance where we go back to something as old-fashioned as a checklist, that there's a checklist that has all the things that we want our employees to look at when an occurrence takes place? A checklist about, to say, are there photographs? Did we retain the video? Did we get the witness statements? Do we have the names of the witnesses? Do we have the plaintiff's name? How did the plaintiff leave the store? Did they walk out under their own power, or did they leave in an ambulance? Those are the kinds of things that we could put on a checklist, which would be a great reminder for our employees, so long as they remember to pull the checklist when the occurrence happens. But that will be part of the primary education that's done when we onboard people or as part of their continuing employment relationship, so that they can watch a computer course that will teach them about this, and then the checklist to be able to reinforce that when the occurrence happens.
Great. One last question, and again, this is the time. Any other final questions, please enter them. For premises owners that use outside counsel for pre-suit investigations, how will the attorney's role change under this new landscape?
Aliana, would you agree that the biggest and most important thing is to get early notice, to try and get there as quickly as possible?
No, I'd agree, because as soon as you have as much information as possible, somebody is aware and can start initiating those investigative steps and collecting and preserving that documentary evidence, you can kind of start the building blocks early, and that's always an advantage.
Well, and we all appreciate that involving attorneys, triggers the privilege, and helps to protect that investigation from unnecessary disclosure. But I think that we understand that if outside counsel is going to do the investigation, that it's immediacy, so that nothing gets lost, nothing gets spoiled.
Perfect. Thank you. Okay. Well, I don't see any other questions in the queue, so I think I'll take this opportunity to wrap things up. Just as a quick reminder, today's program is being recorded. I got ahead of myself here. I got a checklist of my own. Let me just advance this slide. And as always, when you join a Plunkett Cooney program like this, we send you a survey because we really, really value the feedback you give us, especially if you could tell us about topics you'd like us to cover in the future. So if you could, please fill that out. It'll just take you like a minute and a half. The other thing I want to mention is we do have our litigation defenders blog, which is part of our website. If you go to our website, you can pop your email address into that window you see highlighted on the left, and you'll get notice of any updates to our litigation defenders blog. And we cover these types of topics all the time. Lastly, our presentation is recorded. I'll be posting that later today, barring any technical problems, but usually you can get them done in the same day. So if you need anybody else in your organization would like to view it, all you have to do is get them to our website. We'll have it for a few days, at least on our homepage, and you can check out that recording right there. So with that, I will thank everybody for attending on behalf of Rick and Aliana and all the members of our tort litigation practice group. We really appreciate you taking time today. And with that, have a great rest of the day, and we'll see you next time.